Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and for informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. So today we are talking about maximizing trademark protection. We covered what is a strong trademark in the last episode, so go listen to that if you missed it. And then today we're going to talk about who is first and why it matters for trademarks. So have you ever worked hard to be first in line? The lunch line, Black Friday, concert tickets, the latest iPhone, airplane seating. Usually we like to be first. But for trademarks, there are several different ways to determine who is first in line. And the first in line, when there's two people wanting the same trademark rights, the first person in line gets the exclusive rights in most cases. And they're the ones who get the right to use the brand name or the logo. Sometimes people think they're first in line and they're not. So we're going to discuss how first use, first state trademark registration, and first federal trademark registration are different and work together to determine who gets the rights. If you're a small business owner or entrepreneur looking to protect your business brands, be sure to subscribe to our podcast and book a call with us to discuss your trademark strategy. So, first use in trademark means a sale. And long time ago, companies would make a sale. They would just sell one carton of something and ship it across state lines so they could say they had first use and it was interstate commerce. And then there were court cases that said, no, that doesn't really satisfy first use. First use that they're talking about is really you're starting and offering continuously from that point, an offering, whether services or goods, under that brand. And first use does give you some trademark priority on its own without any filing. So what the challenge is that because it can give you some rights, it might also give other people some rights. So if you come up with a brand, you look on the Trademark Office website, which isn't too terribly hard to search, not the greatest, but and nobody has registered this trademark. That doesn't necessarily mean it's completely available. You're going to properly find out if that name is available. You want to see, is somebody else already using that on a business that's going to be considered a similar business to where consumers would be confused to have two businesses with the name or similar names in the marketplace. So searching in state trademark databases, in business directories, LLC names, names on social media, if they're being used as a business name. So these are areas where you will want to research when you are trying to establish a new brand, or also determine if the brand you've established is actually first and if you have good priority for that brand. So what I encourage is look at the brands that you have and write down the names of those brands, as well as the brands that you plan to use in the future. So brands that you're already using, I encourage you to gather proof of the first sale using the brand, or really the first sale that you can clearly document. What happens is there are some cases where two people or two companies file for similar trademarks at the same time or within a few months or even a few years of each other, can be close enough. And the question then often comes down to who used it first, who gets priority. And it goes through a court type proceeding where each side presents their evidence and says, my evidence is good for these reasons, their evidence is bad for those reasons. What happens is, if you claim you have a first use date, but you can't substantiate it, if you can't come up with evidence to prove that specific date, it can weaken your court case if you're in one of those battles. And with a trademark, you don't necessarily have an all clear when the Trademark Office approves your trademark. When you file a trademark, they're going to do research at the Trademark Office is, and their focus is in trademark registration database. It could happen that a different company has been using this brand, you weren't aware of them, you get a registration, and then a year later, they come and say, wait a second, we've been using that brand for many years, and they can actually oppose your trademark and actually ask to have it canceled. If you do things properly, you can make it so that after 5 years of your registration, then somebody can't come in and claim and actually do that cancellation proceeding based on their use prior to your first use. Having that risk out there, you want to minimize that risk when you're applying for a trademark, and the best way to do that is with some good research to determine, is your first use date before other people's first use date? And having that evidence gathered is very helpful. Now, one other thing that makes a big difference about first use is, I mentioned how it's actually filing a trademark application before you use the trademark. And that's a federal trademark application. As I said before, the practice many years ago was for companies to package up something in order to be able to say they've used it, because the Trademark Office used to say you have to use a brand before you can register for it. And so companies would use a brand and then file a trademark application. That way they could make sure the process is going to work out before they invested a lot of money into that brand. Well, now they made a new process to where you can file for a trademark before you use it. The Trademark Office will do their research, and if they approve the trademark, you still have to prove that you use the trademark before they will grant the trademark rights. Trademark rights are only granted for trademarks that have been used in commerce or with a sale. So when you file for that trademark application before you used it, they treat that filing date of that application as your first use date, even though you didn't actually use it on that date. If anyone starts using after that date, they're not going to be able to claim priority over you, even though you haven't started using it. And you get 6 months after they approve the trademark to show your use of it, and you can get extensions up to a total of 3 years. So you could be several years ahead of the game and have that trademark locked down so that nobody else can start using it. There's a lot of trademark battles where if someone had done that, they would win the trademark battle easily. But because they didn't do that, and the there are two parties that have both are applying for a registration at the same time, the Trademark Office has to go through a process to determine who really is first, who gets this right. Now, state trademark registrations can be confusing. Most states, all of them as far as I know, offer a trademark registration in the state. What happens when you file a trademark registration, from what I've seen in Arizona and appears to be the same in other states, the Secretary of State or the Corporation Commission, whoever is put in charge of those trademarks, they just check to see, is this exact term already registered as a business or a trademark in our state? They don't check the federal database. They don't check if others are using it, and they don't have the resources to really check, is this very similar to a brand that is even on their registration database? So the state trademark registration, it does, put a, marker down saying this is mine, but it doesn't give you any exclusive rights, no presumption of exclusivity in court. And very often whoever filed that has a mistaken belief that they've been approved for that trademark, even though there wasn't a good approval process. The Federal Trademark Office, they hire attorneys as their trademark examiners, and that's what those attorneys do all day, is they just work on trademarks. State Secretary of State offices or corporation commissions, they don't have a dedicated attorney to be examining trademarks and making a determination. And in their paperwork, they say that the state Secretary of State will say, you need to do your own research. We don't grant exclusive rights to trademarks, but we'll register them. So if you're using a trademark without a registration or with a state registration, your rights are limited to how far you can prove that's become known as a brand. We're out of time. Thank you for joining me. We'll have another episode coming up in just a few minutes. I'm Wayne Carroll with Leveraging Inspiration.